The power to approve the bylaws of the stock exchange. Section 9 of the SERA provides that any recognized stock exchange may make a bylaw for the regulation and control of contracts, which was previously approved by SEBI. Such bylaws may provide the submission for periodic settlement carried out by the clearing office of SEBI and publications of such particulars of clearinghouse just to subject to SEBI directions. Such bylaws has been published for public comments and after approved by SEBI shall have been published in the Gazette of India. Also, the official Gazette of State, unless SEBI written with the reason disposed within the conditions of previous publications. Power of SEBI to make an amendment bylaws and recognize stock exchange section 10 and section SCRA. SEBI may either on request of return received by it is on behalf of the governing body by recognized stock exchange or on a motion make bylaws on the matter specified in the section 9 of SCRA and the amendment on bylaws made by such stock exchange. SEBI has been satisfied after the consultation with the ongoing body of the stock exchange that is necessary for expedite in this making an amendment bylaws and record the reason also. Licensing of dealers and with securities or certain sections. Section 17 SERA. SEBI has been empowered to grant license to any person for the business of dealing of securities in any state or any area. To Section 13 of SERA has not been declared to be applied. Section 13 of SERA deals with the contracts as notified area to be illegal in certain circumstances. Public issue of listing of security referred to Section 2 HIE of SERA. As per the Section 17A, securities of nature referred to Section 2 HIE shall be offered to the public as offered to listed any stock exchange unless the issuer fulfills eligibility criteria and fulfills a complies with other requirements as may be prescribed by SEBI by regulations. Power to delegate. Section 2 Clause 29A of SERA provided that central governments may by other publications in official gazette direct the power to exercise it under the provision of SERA shall relation to the matter subject to the condition that may be any specified by the order and accessible as may be as Reserve Bank of India. More power for SEBI. Certain additional power regarding to certain provisions under the Companies Act or certain relating to issue the transfer of securities and non-payment of dividend in the case of listed public companies intended to get their securities listed in any of the recognized stock exchange shall be administered by SEBI. About to regulate the prohibit issue of prospectus of a document or advertisement or soliciting money for issue of security. Section 11A. As per the section, the board may by the for the protection of the investor specified by regulations or plus general or specific order specific regulations the matter relating to issue of capital, issue of and transfer of securities and other matter incidental thereto, and the matter in which such matter shall be disclosed by the companies by general and specific order. The prohibit any companies from issuing prospectus or any offer documents advertisements soliciting money for public for the issue of securities or from documents or advertisement resulting money from public for issue of securities. Specify the conditions subject to which prospectus such offer documents advertisement it is not prohibited may be issued. Board may specify the requirement for listing and their transfer of security or any other matter therefore. Collective investment scheme. Section 11A. Any scheme or arrangement which satisfy the conditions referred to subsection 2 or subsection 2A shall be collectively investment scheme. Provided that any pooling of fund under the schemes or arrangement which is not registered with the board, it is not covered under section 3 invoice corpus amount of 100 crores rupees or more shall be deemed to be collected in a scheme in one corpus amount of 100 crores or shall be deemed to be collective investment scheme. Recursive condition. Any section 11A2. Any scheme or arrangement made or offered by any of the person under which the contribution or payment made by the investor, whatever name called or pool that lies for the purpose of the schemes or arrangement. The contribution or payments are made to such schemes or arrangement of the investors within the view to receive profit, receive income, receive the product, produce or receive property, whether movable, immovable from such schemes or arrangement. Contribution in the property, the contribution or investment forming part of the schemes or arrangement which is identifiable or identified not, it is managed on behalf of the investor. Investors do not have day-to-day control over the management and the operation of the schemes arrangement. Section 2. Section 11A to any schemes arrangement made or offered by any person satisfied that conditions as may be specified in accordance with the regulation made in the Act. Exemption section 11A does the following schemes or arrangements shall not be collective investment schemes made or offered by the cooperative society registered under the Cooperative Society Act 1912. The society being conducted, a society being a society registered or deemed to be registered under the law relating to corporate society for the time being force against it. Under the deposit or acceptance by the non-banking financial companies defined under the Clause F of Section 45(1) of the Reserve Bank of India Act 1934, being a contract of insurance, which is the Insurance Act 1938 applies. Provision to any schemes, pension schemes, or insurance schemes framed under the Employees Provident Fund or Miscellaneous Provisions Act 1972. Under which deposits are accepted under the Companies Act 1913, under any other deposits are accepted by the company declared as Nidhi at Mutual Benefits Society Companies Act 2019. Following the meaning of chit fund or defined under the Clause D of Section 2 of Chit Funds Act 1982, under the contribution made or the nature of subscriptions into a mutual fund. Under the schemes or arrangement with the central government may, in consultation with the board, notify. Power to issue directions and power to levy penalty. Section 11B. Save as otherwise provided. Section 11. If after making or causing to be made an inquiry, the board is satisfied that it is necessary. In the interest of investor or ordinary development of security matter, to prevent the affairs of the intermediaries or other persons referred to Section 12 being conducted in manner detrimental to interest of investor on the security market, to secure the proper management to any intermediate person. Board may issue director refer to Section 12A associated with the security market to any person or class of persons. Board may issue direction. Board may issue direction to the companies in respect of manner specified in 11A to its interest of investor security to security market. Levy penalty. Board may by order variation by recorded in writing or levy penalty under Section 15A, 15D, 15C, 15D, 15E, 15EA, 15EB, 15F, 15H, G, 15H, 15HG, 15HB, and under holding an inquiry in a prescribed manner. Explanation. Furthermore, affidavit is hereby declared that power to issue direction under the section shall include shall always be deemed to have been included the power of direct of any person who may profit or await or loss by inducing any transactions or any activities in the contravention to the provision of the Act or contravention provision of regulations made thereunder to disgorge amount equivalent to the wrongful gain made or loss averted by such contravention. Investigation. Section 11C. Ground of issue of the order of investigation where the board may recognize reasonable ground to believe that transaction security can be dealt with the manner determined to the investors or the security market. Any intermediaries of any person associated with the security market has violated any of the provision of the Act or the rules of the regulations made or directions issued by the board and thereunder. It may be a time for order in writing or direct any person therefore section refer to the investigation authority specified in order to investigate the affairs of the intermediates and the person associated with the security market to report therein to the board. Furnishing of relevant documents to the investigation authority. It shall be a duty of every manager, every managing director, every officer, every employee of the company, and every intermediate referred to the section 12, or every person associated with the security market to preserve and to produce to the investigation authority any person authorized to it in behalf of all the accounts, registers, and other documents record of or relation to it company as the case may be of relation to intermediate of such a person which is in custody of power. Period of custody. Investigation authority may keep in the custody any books, any registers, any documents or record or produce for 6 months. Thereafter shall return the same to any intermediary or return to any person associated with it for 6 months. purchased for 6 months and thereafter shall return the same month. 6 మాసాలకు అప్పుడు for any person subsidiary for the security market by whom on which books of the account register or other documents or records are produced. Investigation authority may call off for any books, any register, any other documents are recorded if they need it again. If a person to whom we have the books or register or the documents or records are produced, likewise certified copies of books, register, other documents or record produced before the investigation authority. It shall give certified copy to the books, register, and other documents and record such person or on behalf of the books or register, other documents or record certificate copy of the examination of any person, any director to make an investigation may examine on both any manager, managing director, officer or other employee of an intermediary or any person associated with the security market in any manner relation to the affairs of the persons or any discriminatory or both accordingly. For the purpose may require any of these person to appear before it personally. On failure, if any person fails without reasonable cause for refuses failure to comply to produce the investigation produce to the investigation authority or any of the person authorized by it to behalf any of the books, register, and other documents for a cause which is duty to produce, furnish any information which is duty to be furnished, to appear before the investigation authority personally or to answer any questions which is put to him by the investigation authority is pursuance of his subjections or to sign the notes of any of the examination. If he failure to comply with punishment shall be in person on the terms which may be extended for 1 year, extended to 1 year, the fine which may be extended to 1 crore rupees or with both. Also the fine which may extend to 5 lakh rupees every day and after the first day during the failure or refusal to continue. Notes of examination to be used as examination. Notes of any examination shall be taken down in writing or shall be read over to or by or signed by the person examined and may thereafter be used in evidence against him. Impounding of documents. Where the course of the investigation authority may reasonable ground to believe that the books, registered and the documents and records in relation to an intermediate or any other person associated with the security market in any other manner may be destroyed and multilateral, altered or falsified as account. The investigation authority may make an application to the magistrate or application to the judge of such a designated court in the Mumbai as may be notified by the central government in order of the seizure of such books, seizure of records, seizure of other documents and records. Demand of service of other officers. The authorized officer may request the service of any police officer or any officer of central government or both or to assign him for all or any of the purposes specified above with respect of the impounding of documents, and it shall be duty to every officer to comply with such requisition. Order court after consideration the application and hearing the investigation authority, it necessary the magistrate or judge or the designated court may by order authorize the investigation authority. To enter such assistance as may be required to place of a business or which or books or register or documents or records are kept to research the place or those places in the manner specified in the order and to seize the book, to seize the register, seize the other documents and records considered necessary for the pursuance of the investigation. Exemption and the provided the magistrate or judge or designated court shall authorize the seizure of books, register and other documents and record any enlisted public company being an intermediate specified in section 12, which is intended to engage a security listed to any unrecognized stock exchange unless the company indulges in insider trading or market manipulation. Important documents will remain in custody of investigation authority. The investigation authority shall keep in custody of the books and investigation authority and keep in custody of the register of the documents as the records is under the section of the period not less than conclusion of the investigation. 6 months for examination, but this is different. It is considered necessary, therefore shall return the same to the company or any other body corporate, or the case may be to the managing director or the manager or any other person for whose custody or power they are seized, and inform the magistrate, inform the judge of the designated court for such return. Provided that the investigation authority may before returning such books or register other documents and records are for place identification mark on them and for the firm. Every search and seizure made under the section shall be carried out in accordance with the provisions of criminal proceeding 1973 regular search and seizure under the seize and desist procedures section 411D. Even board finds out after causing an inquiry to be made that the person has violated and likely to violate any provision of the Act and any rules regulation made therefore. It may pass an order requiring the person to seize and designate the committee for a single committing any cause of such violation. Provided that the board may shall pass an order in respect of the original person or public company other than intermediate specific section 12, which indicates security listed under the Securities Stock Exchange unless the board has reasonable grounds to believe that such company has induced in the insider trading or the market manipulation. Register certificate section 12 provision ready to provide the person who is authorized to buy, sells and deal the security provide stock exchange brokers, sub-brokers, share transfer agents, bankers to issue, trustee or trustee are registered to issue, merchant bankers, underwriter, portfolio manager, investor, advisor, such may be interpreted who may be assigned in the security market shall buy, sell or deal with securities according to the condition of the securities registered obtained by the board. Obtain securities accordance with the regulations under this act. Board may notifications specify the person who shall buy or sell or deal security, depository, participant, custodian of security for an institutional investor, credit rating agency, or any other intermediate organization for the security market as per the board may be notified on the behalf of the specific shall buy or sell deal security according to the conditions specified in the register obtained from the board in accordance with the regulations made in the act. Person who shall sponsor or cause to be sponsored or carry out the cost to carried on any venture capital fund and collective investment schemes including mutual funds shall be who obtain certificate of registration from the board in accordance with the regulations. Person who shall sponsor or cause to be sponsored or cause to be carried on the activity of the alternative investment funds or the business trust defined under section 13A of the section 13A of Section 2 of Income Tax Act 1961 shall be who obtain certificate of registration from the board according to the regulations. A manner of application of registration. Every application for registration shall be in such a manner, or payment of such fees or may be discounted by regulations. Suspension, cancellation, certification programs. The board may, by order, suspend or cancel certification of a registration such manner as may be determined by the regulation, provided that no such order or subscription shall be made unless a person concerned has been given reasonable opportunity to be